Let me bring back in my guest, criminal defense attorney Lara Yeretsian. Now, she's one of the attorneys who represented Scott Peterson during his murder trial. And I guess the first question I have to ask you, Lara, is what exactly do you think they're providing for the prosecution in terms of their case? We certainly know they're providing emotion. We also know the tape itself provides that. What else do you think they're providing?
What they're providing is lay people, people who, and some who have some experience and training in medicine. You've got the EMT and one who's got the mixed martial arts and was a wrestler, people who could watch and see that George Floyd was in distress, that George Floyd could not breathe, and George Floyd was actually dying. But for some reason that was not evident, or the officers didn't act on it, didn't do anything to help George Floyd. That's exactly what they're doing.
Now, we've heard from a couple of them that I believe it was Donald Williams and also one of the younger witnesses testified that what they saw was Derek Chauvin shifting his weight and putting more weight onto the neck, and that he was almost responding to their cries of get off him or do something, or they wanted to help, and some of the things they were saying to him, they say he was kind of almost responding to that. And I'm wondering if that might help provide intent. One of the things that Jerry Blackwell said in his opening statement was that intent is going to be sprinkled throughout. That you're not going to hear any specific testimony about intent, but intent will be sprinkled throughout, which I found interesting. And I'm wondering if this testimony where they talk about him putting extra weight on Floyd's neck, even as he's passing out, that might be part of what this jury can use to find intent.
And it's very possible, like you said, and as Jerry Blackwell argued, I mean, intent is not something that's clear you can point at and say, well, that's intent. Intent is going to come up through a litany of evidence, and in some ways it's going to be circumstantial, and there's going to be inferences drawn from some of the evidence and some of the actions done by the individuals involved. And in this case, specifically, what you're talking about is him shifting his weight and moving his knee and maybe digging in deeper, especially when Mr. Floyd is no longer resisting, and you've got a crowd screaming at you that he's distressed and he needs to breathe. I think that goes to show that maybe he was maybe reacting to the crowd, or also being a little harsher than necessary. Did he really need to use that kind of excessive force to keep Mr. Floyd on the ground? Was there something else he could have done? Maybe take some of the weight off of him, change the position that he was in, whatever it was he could have done. And I think, that could go to show, I mean, I'm not sure eventually where this jury is going to fall, but it does show that this officer should have done something different than what he was doing.
Yeah, no question. And, the defense, they've got to tread lightly. These are very emotional. These are young kids. It's often difficult, and they chose not to cross-examine two of them. But the ones that they did, I thought he did a masterful job of asking them questions that helps out his theory that this mob or these folks around them kind of distracted the officers or made them more leery of letting George up.
Yes, and that's what a defense attorney is supposed to do. You have to be careful what you do with witnesses, especially young witnesses. You can't be too aggressive with them. They just happen to be bystanders. They're not even parties necessarily to the action. They're just bystanders. They're witnesses, recipient witnesses. So he had to be very careful as far as how he approached them. But you're right. He was masterful. He got what he needed. He wanted to show that this mob, this group, they were an unruly mob, and he was trying to get her to show that yes, there was anger, there was screaming, and you know what? Could that have distracted the officers? Of course, it could have distracted the officers. One of the arguments that the defense is going to raise later is that the officers were probably worried about their own safety. Right? So then it's a balancing act, and they've got split seconds here to really decide what to do to keep the crowd away, the unruly crowd away from them, to make sure they've got the suspect on the ground, Mr. Floyd on the ground, and keep him there, and also make sure that they are safe. So these are all things that the defense is going to have to bring out through different witnesses, and I think they're doing a great job. Yeah, Eric Nelson is doing a great job.
Yeah, I think he's done a great job too. All right, let me bring back in my guest, criminal defense attorney Lara Yeretsian. Now, Laura, you know, the defense has two tracks that they're going down in terms of defending Derek Chauvin. One is that this crowd was unruly and that they made it difficult for them to do anything more as far as the standard of care is concerned, that they had to be concerned about this unruly crowd. The other is, of course, the cause of death. But I want to focus on the first one. They're really going down this line, and when they did the cross-examination of that witness, Darnella, they got her to admit that there were 12 to 14 people, and as time went on, they continued to get more upset. That's basically what they got, that type of thing, from a lot of the bystander witnesses. But my question to you is, does it make sense to go down that track when, as far as I'm concerned, and let me get your opinion on this as well, the video doesn't seem to support this theory of an unruly crowd. Do you think it's still worth going down that track?
Videos aren't always the best evidence. Sometimes videos don't show. Whoever's at the scene can give you a better description of what was going on. I mean, you may not hear everything on the video. You may not see the different views or everybody and what everyone's doing at that moment on a video. You'll see bits and pieces or one view or from one vantage point. Whatever it is, it's not always comprehensive. The experience is a little different and fuller when you're at the scene and a percipient witness, and that's important. And it's important for him to ask those questions. He can't just rely on the video. I mean, it would be ineffective assistance if he doesn't ask those questions, really.
And actually, I think you're right, Laura, because he actually promised in his opening statement that he was going to bring in some other video, I guess CCTV video from a restaurant across the street that would give the jury a wider view and give them more a sense of some of the chaos that might have affected the officers at the scene. And so at the end of the day, I thought the hardest part of their case was to explain why they didn't do more and why they kept holding him down. Specifically, Derek Chauvin kept his knee on his neck after he had stopped moving. And I think he accomplished that a couple of times today. One, he got Donald Williams, one of the bystanders, to say that after you get choked out and you're sort of passed out in a fight that you're in, have you ever woken up and started fighting again? Right? And he said yes. And I thought that was an important thing to get out because, again, I think one of the things he's going to argue is after sort of George Floyd passes out, the reason he doesn't let up is because he's afraid that he could wake up and begin to get violent again.
And that's I understand that. He did a great job with that. And I'm sure the police officers have encountered that on many, many occasions, and hence their training. I mean, they're following their training, their policy. They've got procedures that they're supposed to follow. If there's a crowd around them, they're supposed to keep things under control, keep the suspect on the ground, especially a suspect who's been fighting them, who's not cooperative. And, you know, that was a great question because the witness used his own experience and gave an example to the jury about what he had encountered, and basically that supports something that was probably going through Chauvin's mind and the minds of the other officers. So I think he did a great job with that question. And I think we saw a little bit of that with Genevieve, too, when he was trying to get her to admit, you know, what she would do in a situation when there's people yelling and screaming at her, 12 people screaming at you, telling you you're doing something wrong. And yes, she didn't give him what he originally wanted, but she said something else that really jumped at me, and I thought it was very important. And that was, you know, I know my training, and I won't get distracted by others, which is basically what the defense can argue later Chauvin was doing.
Yeah, I have to agree. You know, you're hearing, as a defense attorney, you're sitting there and you're hearing these answers, and you can see how the defense is going to incorporate that in their closing arguments as he continues to build his defense through these prosecution witnesses. And I think ultimately, as a defense attorney, there's not a lot more you can ask. I mean, that's really what you have to do with these types of witnesses. And these are young witnesses, so they do present special challenges.
Definitely. I mean, you almost have to surgically go in, ask a few questions, hit a few points that you need for your closing argument, and be glad that you got those, especially with the younger witnesses.
Yeah, I want to play another quick bite from Darnella when she was on the stand. Again, it's a very emotional thing, and I want to discuss with you, how do you sort of back up on something like that? Let's take a listen.
So can you see the person depicted on Exhibit 17?
Yes.
Darnella, are you able to tell the ladies and gentlemen of the jury if you know who this man is? You can take your time.
Yes.
Please tell the ladies and gentlemen, who is this?
This was the officer that was kneeling on George Floyd's neck.
On May 25th.
Yes.
Is this the way he appeared when you saw him on May 25th, kneeling on George Floyd's neck?
Yes.
So again, that's indicative of a lot of the emotion that we saw today. But yet again, as we said, I thought the defense undercut some of that with some of their testimony. And it's not going to be apparent right away, but I think later on it may come back to play. So overall, do you think the defense did a strong job of dealing with what really was really strong testimony for the prosecution?
I mean, they did the best they could. I mean, these were all great, strong witnesses. I mean, emotions are high. And this is a highly emotional case that's gotten the attention of the entire world. So we know that these are important. And, you know, the prosecution knows that emotions are important in this case, and that's going to help them with the jury. And some of these witnesses, especially the younger ones, their testimony was powerful because they can relate. They can personally relate. I mean, one of them said, Darnella says that this could have been her father, her cousins, family members. So she's very much traumatized by this. I mean, it goes without saying that powerful witnesses for the prosecution, and the defense did the best they could. There's so much you can do with some of the witnesses. I think he's doing the best he can at this point. There will be other witnesses where he could do probably even more, but he's getting what he needs out of these witnesses.
Yeah, and I think at the end of the day, the argument that he's going to go with that we see often be successful in these cases versus police officers is to tell the jury that you don't really want to substitute your judgment for the police officer on the scene. You know, the officers were at the scene, they could feel the temperature of what was going on, and they decided that this was the way to act. And juries are often loath to put their judgment in the place of police officers.
That's true. And in this case, maybe it'll help with the murder charges, but there may be still an issue, despite all those arguments, with the manslaughter, right? It's an unreasonable risk here, regardless of what's going on through the officer's mind. So the defense, I mean, they have to do what they're doing, and it might help. A lot of these arguments will probably help with the second degree and the third degree murder charges that involve a lot more of the intent. I mean, they're not for the unintentional, it's an unintentional act, but it's an intentional felony assault. So, and the imminent danger idea. So here, it'll help for those two, but they still have a problem with the manslaughter charge.
Yeah, they certainly do, but I'm not sure manslaughter is going to be enough. We'll have to see. All right, Laura, stand by.
Objection, non-responsive.
The answer will be stricken. Wait for the question and then answer the question that is asked.
It's a yes or no question, ma'am. Is it reasonable to assume that if a patient is having a medical emergency and the police are present, that they have called for EMS?
Your question is unclear because you don't know my job, so
Okay.
can't answer.
Sure.
All right, let me bring back in my guest, criminal defense attorney, Lara Yeretsian. And Laura, I think it's typical there. You'll see oftentimes when a witness is on cross-examination, they kind of get a sense of what the defense attorney is trying to get from them. And so they get to be a little bit evasive. I want to know how you deal with that as a defense attorney. Let's say you're putting a witness up and they're on cross-examination. I often used to tell them, look, stick with the yes or no's. You're better off than trying to go toe-to-toe with an attorney.
I mean, it's happened a lot where you've got a combative witness, a witness who is, let's say, the prosecution witness, and they do great on direct, right? They come across as very solid. But I mean, it's easier to come across as solid on direct because you know what the questions are and you're ready for them. Cross is a little different. You have no idea what they're going to cross-examine you about, and what questions they're going to ask you, and how they're going to ask you the questions. The cross-examiner, in this case the defense attorney, Eric Nelson, is trying to get her to admit to certain things. And some of those things are reasonable things. I mean, just common sense, right? And she's fighting him on it. And that's not doing her any service. In fact, as a defense attorney, I cherish those moments where a witness who was strong suddenly is being combative and is being unreasonable and is not admitting some basic common sense things that the jury can see. She almost doesn't even have to answer. The jury knows the answers. You don't have to be an EMT to answer some of these questions. You don't have to be Genevieve to answer those questions. And she would have done a lot better if she had just given the yeses and nos instead of fighting. It's
Exactly.
not
Just
helping her.
stick to the yes and no's, as I always tell them. You know, it's like, don't try to go toe to toe. It's just not a good idea.
Right.
And actually, by doing that, getting combative, she kind of plays into the defense's theory that at the scene, their combative nature made it difficult for the officers to do anything other than they did at the time. So still with me is criminal defense attorney Lara Yeretsian and Court TV legal correspondent Julia Janae. She is live in Minneapolis, Minnesota. All right, let's get to our first statement, and that is from Rhiannon Gallagher. He says he didn't feel threatened. He knew exactly what he was doing. The officers got the reactions from those bystanders because those people were witnessing a man dying. And Laura, you know, that raises an interesting point. It's almost this circular argument. It's almost as if they would have let up, then probably the crowd might have let up, you know, but the crowd is on them, so they're saying that's why we didn't let up.
Exactly. It's a great argument, obviously, for the defense. And the prosecution is going to show you the other side, that if they let up, the crowd wouldn't be reacting the way they were. The crowd, they were watching a man die. What were they supposed to do? I mean, as a human being, you can see some of the guilt some of these witnesses, the younger ones, are feeling. Even the EMT is feeling. I mean, these are people who are thinking, we could have possibly done something. Maybe we should have done more. And they're feeling that the guilt and a lot of emotions here. And if it was that evident to these people, to the crowd, why wasn't it evident to the officers? But again, the argument is going to be, like you said, it's that circular argument. Well, because of their reaction, we couldn't let up. So we'll see how that plays out. We'll see how the jury is going to react to all of this.
Yeah, that was
extremely interesting.
Our next comment from Amy Woody. With as many people that were gathered around, yes, I do think all of the officers that were there knew things could get extremely bad. You see, Laura, here's where the problem comes in, and why I think this defense needs to be looked at closer than, you know, and given a lot more credence, because you only have to find one juror who feels like Amy Woody. The fact that they were acting and did the things that they did, when we're asking the question, why didn't they help more? There's folks who are going to think, hey, they were doing what they had to do to control the situation.
Exactly. I mean, that's what the defense is counting on. Like you said, possibly one and maybe more jurors who are going to feel that these officers were following procedure, following their training. And if you've got a crowd around you screaming at you, getting angrier and angrier by the moment, what does their training tell them to do? To keep everything under control. That's exactly what they did. And like you said, all they need is one.
Yep, you can't discount that defense, I'm telling you.